The administration just unveiled a major legal reversal and people are acting like the battle is finished. But here's what the headlines won't tell you. There's a statutory trap so treacherous that federal agents could still knock on your door tomorrow morning over that pistol brace in your safe. And right now, there's only one lawsuit blocking that path. Let's slice through the celebration and examine what really matters here. The Trump administration's Justice Department recently grabbed attention by consenting to abandon their Fifth Circuit challenge in a pivotal case targeting the pistol brace regulation. On paper, this appears to be an enormous triumph for firearm owners nationwide. The prior administration's maneuver to reclassify all stabilized pistols as short-barreled rifles seems to have collapsed. Victory declared. Case shut. Right? Incorrect. What's unfolding beneath the surface at this very moment could dictate whether pistol braces stay lawful for the coming decades or transform into a legal landmine waiting to detonate beneath millions of Americans. You see, there's a crucial distinction that virtually everyone is overlooking in this scenario. The regulation itself may have vanished, but the foundational legal theory that spawned that regulation remains perfectly intact. And that theory is precisely what makes this entire circumstance so dangerously unstable for countless gun owners who believed this struggle had concluded. Let me walk you back through how we arrived at this point. The previous White House chose to construct a fresh regulatory architecture that would have compelled anyone possessing a braced pistol to either catalog their weapon under the National Firearms Act, destroy it, surrender it, or confront potential federal felony prosecution. This wasn't some insignificant policy tweak. This was a radical reimagining of what constitutes a controlled firearm under federal statute. Numerous legal actions were initiated across the nation contesting this regulation. Firearm owners, advocacy groups, and even state authorities rose to oppose what they viewed as extraordinary federal encroachment. Eventually, a federal jurist delivered a ruling that annihilated the regulation entirely on a countrywide scale. This was monumental. It meant the enforcement operations, the registration timelines, the impending threat of criminal charges. All of it screeched to a halt. When the new administration assumed power, they examined the pending appeal and reached a conclusion. They consented to abandon the contest. They agreed that the previous nationwide order freezing the regulation would stay completely operative. They essentially declared the regulation is deceased. We're not going to champion it anymore. Let's proceed. Now, here's where matters become genuinely fascinating and, frankly, somewhat alarming. Following this development, several other pistol brace legal actions across the nation were resolved and terminated. The government's stance was straightforward. The regulation has evaporated, so there's nothing remaining to dispute. These matters are moot. Everyone can disperse. But one legal action is declining to fade silently into obscurity, a challenge brought by a prominent gun rights organization alongside the state of Texas, and Attorney General Ken Paxton is resisting this narrative. They're asserting something that should cause every pistol brace proprietor to lean forward and listen carefully. The conflict isn't genuinely resolved, not by a long shot. Their argument focuses on a fundamental defect in how this entire scenario has been settled. The original regulation was demolished on technical grounds. The court determined that the final regulation didn't appropriately derive from the proposed regulation, which constitutes a technical breach of administrative procedure mandates. But here's the essential element that everyone appears to be minimizing. The court never actually repudiated the government's foundational interpretation of what the law states. Consider what that signifies for a moment. The regulation has disappeared. Affirmative. But the ATF's position that braced pistols can be categorized as short-barreled rifles under the existing statutory text of the National Firearms Act. That interpretation is still perched there, entirely unbroken, prepared to be deployed again. This isn't some abstract worry. According to recent court documents, there have been instances where enforcement measures grounded in this interpretation have persisted even after the regulation was supposedly obliterated. So, we have some significant developments in the opposition to the ATF's pistol brace regulation. So, the ATF is at it once more. You'd imagine, after being rebuffed by federal courts repeatedly, they'd absorb the lesson. The final regulation on evaluation criteria for stabilizing braces is no longer active. Firearms Policy Coalition has prevailed in their legal action against the federal government. So, essentially, Essentially, what they communicated was, we're not going to proclaim victors. We're simply vacating this regulation. Pistol brace is illegal, or declaring that your pistol brace-equipped pistol is a short-barreled rifle that's eliminated, even after the new administration concurred that the regulation was no longer enforceable. The legal premise that pistol braces convert a pistol into a controlled firearm hasn't disappeared. In their communication to the court, the challengers indicated something that should send shivers through your body. They observed that without appropriate injunctive protection, the government is positioned to simply persist in enforcing the identical restrictions by citing the underlying statutory framework. So, abbreviated version here is that the DOJ has consented to dismiss its appeal in Mock v. Bondi. Not only are we not going to enforce these, but we are not going to allocate any funds for enforcement of these. The ATF overreach has been halted once more. They genuinely don't comprehend how to handle this one, which is perpetually a positive indication to witness. Finally concludes a highly arbitrary and authoritarian episode in the Government Overreach Chronicle. The Department of Justice has abandoned their pistol brace lawsuit. The Trump DOJ recently stipulated to the Fifth Circuit that they have consented to drop the active appeal on the entire pistol brace matter. They don't require the regulation anymore. They can simply point to the National Firearms Act and assert that braced pistols satisfy the definition of controlled firearms under the existing text. This is precisely why the continuing challenge is so vitally important. Rather than accepting termination and departing with what resembles a victory, the plaintiffs are requesting something far more consequential. They want the court to issue a permanent injunction that would prevent the ATF from enforcing any interpretation that treats braced pistols as short-barreled rifles, whether through a formal regulation or through direct application of the statutory text. And now, that determination by the DOJ to abandon the mock lawsuit is influencing even more pistol brace cases like that. One companion who maintains they can repair their vehicle by striking the tire. The ATF simply keeps escalating on their pistol brace absurdity. Even preceding this regulation, there were some ambiguous and rather vague guidelines on braces with considerable vacillation from the ATF. You had to register these pistols that were outfitted with the pistol brace and register them as short-barreled rifles. It was somewhat Schrodinger's firearm, I suppose, is how I'm conceptualizing it, because it was simultaneously a pistol and a rifle. If you're going to constrain a constitutional right, it has to be consistent with the nation's historical traditions of firearm regulation. If granted, this category of relief would accomplish something that none of the other settlements have achieved. It would genuinely seal this matter. It would prevent any future administration from simply resuming where the previous one ceased. It would establish genuine, enduring protection for pistol brace proprietors instead of this temporary armistice that could terminate at any instant. It stated, in part, that firearm regulations must be consistent with the historical tradition of firearms regulations in the U.S. Recently, multiple pistol brace legal actions that were initiated in response to what the Biden administration executed have been dropped and settled as moot, courts pronounced. In common use, that's prohibited. Clearly, pistol braces are in common use. First and foremost, basic firearm safety does not have to be a threat to the Second Amendment. Targeting pistol braces has been ongoing since 2023, and if the ATF had their preference, they would have gladly transformed millions of lawful gun owners into felons. In 2012, the ATF stated that attaching a brace would not modify the classification of a firearm. The court has now concurred that this issue merits further examination. They've mandated additional briefing to determine whether the case is genuinely moot or whether there's a legitimate need for permanent injunctive relief. The government will have the opportunity to file a motion to dismiss and explain why they believe everything is settled. Then, the challengers will respond with their arguments for why the threat remains genuine and active. Rather than dismissing the case, they requested for the court to issue a permanent injunction to block the ATF's current interpretation of the NFA. First of all, it's crucial that you know the firearm and concealed carry laws in your home state, and anywhere you intend to carry one less thing gun owners have to worry about. This means you can continue to employ them how you've been employing them for years, or the subjective use of a brace as a shoulder stock would alter the classification from a pistol to a short-barreled rifle. This is not a firearm decision. No, it's it's not. This was not decided on Second Amendment grounds. Also, that ruling was only based on an APA procedural issue, which could be remedied by any future anti-gun administration. Here's something else that's worth contemplating as we observe this unfold by consenting to abandon all these cases and accepting settlements. Gun rights advocates secured an immediate practical triumph. The regulation is gone. Enforcement has ceased. People can exhale somewhat easier. But there's a long-term expense to this approach that not enough individuals are discussing. The only binding legal precedent we possess on this issue derives from a single district court decision. That's the most modest level of the federal court system. Essentially, they struck the ATF in the mouth. They appear somewhat disoriented. They appear as though they got their bell rung fairly severely. There's a multitude of things that can entangle you legally, financially, incarcerate you, or perhaps get you in very serious difficulty with law enforcement. And I think it's worth highlighting, hey, this wasn't invalidated on Second Amendment grounds. The appeal from the DOJ with the pistol braces is gone, finished, withdrawn, and it will affect everyone nationwide, and that would now be essentially the law of the land. And the ATF conceded that the pistol brace regulation is now vacated in 2014, stated that the ATF doesn't classify weapons based on how someone employs them. If a future administration elects to take another attempt at regulating pistol braces, they only have to surmount one district court ruling that was based entirely on procedural grounds. There's no appellate court decision establishing that the government's interpretation is erroneous. There's no higher court ruling that pistol braces are protected or that the ATF lacks authority to regulate them. This way, a procedural victory can be repaired. This regulation reclassified large format handguns equipped with pistol stabilizing braces as short-barreled rifles, but when used as a stock with certain firearms with barrels less than 16 inches, then you have an NFA item. That regulation just stated possessing a pistol with an arm brace is definitionally. In SBR, Firearms Policy Coalition and the Department of Justice have reached an agreement where the Department of Justice will abandon its appeal. It does not prevent the current or future ATF from asserting they can regulate pistol braces purely based on the NFA statutory language. There's a possibility braces might end up in the crosshairs again by a new ATF regulation or through legislation. If a future administration desires to pursue pistol braces again, they simply need to be more meticulous about how they draft their proposed regulation and how they respond to public commentary. They can follow all the proper administrative procedures and end up right back where we started arguing the same underlying legal theory that was never actually rejected by any court. The weapons, unto themselves, they're not the problem. The problem is, what are you doing with the weapons? The district court here should instead issue a permanent injunction against the ATF's current and future enforcement of any pistol brace restriction. You need to be on the right side of the law because the legal system is complex. ATF is receiving another lawsuit, this time by half of the nation. So I think it comes down to the definition of what a rifle is. Half a dozen legal actions were filed, and now, finally, here we are. Now that the DOJ is no longer pursuing enforcement action, the proposed pistol brace regulation is now gone. The coming weeks are going to be extraordinarily revealing. We're about to discover what the current administration genuinely believes about pistol braces and how they intend to handle this issue moving forward. Their response to this case will inform us whether they truly believe brace pistols are lawful and protected, or whether they're simply electing not to enforce restrictions currently while preserving their options if they argue aggressively for dismissal and refuse to accept a permanent injunction that should raise serious warning signals. It would suggest they want to maintain their ability to reverse course later, or that they're leaving the door ajar for future administrations to resume this conflict again. The regulation was vacated on procedural grounds. Failure to constitute a logical outgrowth of a proposed regulation is a massive deal. It directly targets the ATF's tactics over the last 2 years, with gun control being implemented in numerous states even where least anticipated. This is not a measure that gun owners should disregard. Not every instrument that is bearable will be protected by the Second Amendment. We in Texas are observing is that the ATF may still be attempting to do something surreptitious with the entire pistol brace matter. The ATF response didn't simply state braces make a gun in SBR. They went further. On the other hand, If they concur that a permanent injunction is appropriate, that would be an authentic victory. It would demonstrate a genuine commitment to protecting pistol brace owners and concluding this chapter permanently. This situation perfectly illustrates why the specifics matter so tremendously in these legal conflicts. Headlines proclaiming victory can conceal underlying vulnerabilities that leave gun owners exposed to future assaults. A settlement that resembles a win today can transform into a crushing defeat tomorrow if the fundamental legal questions are never genuinely resolved. The ATF has consented to abandon some of these lawsuits, and they agreed to not enforce the Biden administration's pistol brace regulation. We are unlikely to obtain a nationwide injunction. The current injunction is still active, and the shooter is still active. Not having this Fourth Amendment to protect you and protect yourself from the police just entering your home without a warrant, that's fairly astonishing. And the government is going to contest this every step of the path, and sooner or later, it will arrive before the Supreme Court. But they may still intend to enforce the restrictions on brace pistols, just purely on the subjective interpretation. Right now, millions of Americans possess braced pistols. They've been informed the threat has passed. They've been told they can relax. But the reality is that their rights are suspended by a filament, protected only by the current administration's election not to enforce an interpretation that remains legally viable. One case stands between that precarious circumstance and genuine, lasting protection. One group of plaintiffs is refusing to accept an empty victory and is battling for something that actually matters. The outcome of this challenge could determine the future of pistol braces in America for generations to come. As this case evolves and new information becomes available, the implications will become clearer. Whether the courts concur that permanent protection is necessary, or whether they decide the current situation is adequate, remains to be seen. But one thing is certain, this conflict is far from concluded, no matter what the headlines might proclaim. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.